Okay, welcome everyone. Thank you all for attending. This webinar will be recorded and put on the website, like I mentioned. If you have questions, please pop them in the chat, and the speakers will answer them as they can or at the end of the call. If you have to hop off on the hour, we completely understand. And with that, I would like to thank all of the speakers today from DMG, and I will hand it off to Kathryn, who will introduce the presentation.
Thanks very much, Annabelle, and hello, everybody. We're very pleased to be here. I'm here with my colleagues, John Mather, Jennifer Dunlop, and Michael Robson. We've put together a little slideshow here, which I guess Annabelle can send to people after if she'd like to, if people want it. We're going to cover two topics today. We're going to talk about commercial arbitration in Canada, and we're also going to cover touch on some areas of cross-border litigation that we thought would be of interest to the network. Just a little bit about our firm. We're a commercial litigation boutique based in Toronto. We have clients across many industries and different sectors, and we've listed a few of them on there: manufacturing, transportation, securities, media, etc. We do all aspects of commercial disputes and arbitration, including some specialties in product liability, commercial arbitration, obviously, class action, defense, shareholder disputes, professional liability, public law, defamation, civil fraud, and privacy and cybersecurity. So pretty broad gamut of litigation, all on the civil side. And we've been, I guess, a member of IMBLF for the last 3 years, I think, and have really enjoyed being part of the Toronto chapter, which is led by Lloyd Hoffer. And also some of us have been able to connect at various events. And so we're really excited to share some of our knowledge with you today. We've got also our bios there. I'm not going to go through them. You can take a look at them after as well, or check us out on our website. So I'm just going to do a quick overview of commercial arbitration and what that is, and then I'm going to turn it over to Jennifer, who's going to get into the some of the rules in Canada, and then I'll come back and talk a little bit about international commercial arbitration. So for those of you who are not familiar with arbitration, what is it? Well, it's a private and confidential process that's adjudicative, but it's outside of the courts. The parties essentially agree either by a contract that then comes into play over in a dispute, or they can agree when a dispute has arisen that isn't governed by an arbitration clause contract. That's not as typical, because typically defendants may not want to agree to a process that will essentially be quicker than the court process. It's a neutral adjudicator, and arbitrators will be either appointed by the parties, or sometimes the contract that governs will have an institutional body that is to appoint, such as in Canada, the ADR Institute of Canada, and that type of body, and they will pick the neutral. The parties will pay for the neutral, whereas in court, we don't pay the judges other than through taxes, but that's separate and apart. So there is that extra expense, but because the parties can come together with the arbitrator and tailor the process, it can actually be a little bit less expensive than litigation, even though you are paying that neutral. So the adjudicators will be chosen by the parties or the institutional body. Sometimes there's a dispute over who will be the arbitrator, but generally speaking, parties in commercial disputes want to get things done on both sides of the dispute. One key thing about arbitration is that the parties will be bound by the arbitrator's resolution of the dispute, and typically the arbitration clause will exclude appeal rights following the decision. So the attempt will be made to keep the dispute and the arbitrator's decision out of the courts. Sometimes that doesn't work, and we do have bodies of case law that arise when parties go to court and try and challenge particularly the jurisdiction of the arbitrator to decide the dispute. The benefits, of course, come in this process when you tailor it to your dispute to achieve true cost savings. If you just treat it like you would a court action and use whatever the rules of court govern here, in Ontario, they're called the rules of civil procedure. You won't save time and you won't save money, and the true benefits of arbitration will be lost. So with that background, I will turn it over to Jennifer.
Thank you, Kate. Kate's touched on a few of these points already, but I just wanted to go into a little bit more depth in relation to how arbitration differs from court proceedings here in Ontario. And again, just a little bit of background. Arbitration, as many of you know, is growing in popularity as a dispute settlement mechanism for Canadian businesses and Canadian courts. And Canadian businesses and the Canadian courts are embracing a differential approach towards arbitration and the jurisdiction of arbitral tribunals. It's mostly used in commercial disputes as a private alternative to litigation, as Kate mentioned already. And it generally allows the parties to design most aspects of the resolution process to suit their needs and the needs arising in the specific nature of the dispute. Arbitration has a number of advantages over the court proceedings process. It's generally more flexible, and the parties can maintain a level of control over and above what they can in the court proceeding process. As Kate mentioned, the parties can choose the arbitrator, and they can agree amongst themselves who they would like to use as an arbitrator. The parties can choose someone they know who will understand and has experience of the subject matter of the dispute, and someone who has a thorough knowledge of the arbitration process. This is considered a huge benefit, because if you're able to choose an arbitrator who has a in-depth knowledge of the subject matter, there's a lot less explaining that has to go into the facts. And so if you're dealing with for example, a construction case, it's much better to be able to choose an arbitrator who has in-depth construction experience, as opposed to in the court proceedings, you're not quite sure what depth of experience the judge that you're going to get will actually have in relation to the subject matter of the case. A significant amount of control is retained by the parties to the dispute. This can ensure faster timelines in a court process. Again, possibly not beneficial to the defendant, but certainly where the plaintiff would want to progress the matters more quickly. The parties and the counsel are able to control procedural aspects of the process, including timing of procedural steps, location of the hearing, and various other points throughout the arbitration. It's more effective and less costly. Again, it's a flexible Oh, sorry, Kate, could you go back? It's more efficient and less costly. The flexibility of the process, again, there's not the same mandatory prescribed steps as with the court process, which will allow for a reduction in time and cost to all the parties. And the parties can tailor the process to suit their timetable, taking into account a number of commercial and business decisions that the parties may be dealing with, and other issues outside the litigation, whereby they want to achieve an effective process based on the business and the commercial timelines that they want to take into account. Unlike court proceedings, the arbitration it's a private process, which generally means that the parties can control the level of confidentiality, and confidentiality can be preserved to the extent agreed upon the parties, which is a huge, that's definitely a huge advantage to arbitration. And finality comes sooner in arbitration if the agreement is properly drafted. Judicial review is limited, and the parties will be able to achieve finality and move on much more quickly, which again tends to suit commercial businesses in relation to the business aspect and the costs for the company. There are a few disadvantages which are not on our slide, and I thought I might just raise a few of them anyway, because whilst arbitration is a very advantageous process, it does come with a level of disadvantage. So I'm just going to mention a couple of those really very quickly. One of the principal perceived disadvantages of arbitration is possibly the cost of holding the arbitration. Kate alluded to the the point earlier that you don't have to pay judges apart from in our taxes, but there is a charge for the arbitrator upfront, and I think parties probably have to balance that idea with the legal fees that then build up over the course of a case and bringing that case to trial. So it may or may not be considered a disadvantage depending on your position, but sometimes the upfront cost of holding the arbitration could be considered a disadvantage. Another possible disadvantage with arbitration would be the difficulty in joining third parties to the proceedings, and also because you can manage the various steps. There's not any mandatory steps of discovery. So sometimes parties would use the discovery process as a way to get information, which can be beneficial. Again, it's a point that could be agreed between the parties, and if there's no agreement on discovery, that could be a possible disadvantage to using the arbitration process, is the lack of discovery and appeal rights. Okay, Kate, you can flip on to the next slide now. Thank you. Arbitration in Canada. Arbitration is regulated by statute in Canada. Every province and territory has its own separate arbitration legislation. And at the federal level, commercial arbitration is governed by the Commercial Arbitration Act, the CAA. The CAA serves principally to introduce the Commercial Arbitration Code, which is a schedule to the CAA. And the schedule provides basic procedural framework for commercial arbitration. The code applies to all commercial arbitrations where at least one of the parties is a federal department or a crown corporation in relation to admiralty or marine law issues, where the place of arbitration is Canada. It's not something that we deal with often in our practice. We would deal more with obviously the domestic legislation. So in Ontario, the relevant domestic legislation is the Arbitration Act 1991, and each province has their own domestic legislation. The domestic legislation in most of the provinces permits the parties to contract out of many of the provisions of the domestic and international acts, but not the ones listed on the slide. I just run through them very, very quickly. So in an arbitration, the parties shall be treated fairly and equally. Unfortunately, we can't contract out of that one. Each party shall be given an opportunity to present a case and to respond to the other party's case. Another clause that we can't contract out of is a clause requiring or having the effect of requiring that a matter be adjudicated by arbitration before it may be dealt with by a court. These clauses under the Domestic Act, so right across Canada, are deemed to have the same effect as an arbitration agreement. Next, the court may extend the time within which the arbitral tribunal is required to make an award, even if the time has expired. And the provision that on a party's application, the court may set aside an award on certain specific grounds, which are listed in the slide: legal incapacity, the agreement's invalid, and various other grounds. I'm rushing slightly because I'm aware of time. I think I'm going over my time slot. And another two.
It's okay. You don't have to rush. We're good.
There are two further provisions. One empowering the court to grant a declaration that an arbitration is invalid on certain specified grounds: legal incapacity, invalid agreement, the subject matter of the dispute is not capable of being arbitrated under Ontario law, or the agreement doesn't apply to the dispute. And lastly, the provision entitling a party to enforce an award and make an application to the court to that effect. Those are all provisions that we cannot contract out of. And I think Kate alluded to this earlier on as well. In Canada, the parties can agree on the rules of arbitration, which are either listed in the arbitration agreement in advance of the dispute, or during a dispute that doesn't have a set of rules in the agreement. The parties can agree on the rules of the arbitration on an ad hoc basis with the arbitrator, or use an institution's rules such as the ADRIC. This institution has arbitration rules that are often used in Canadian domestic arbitrations, and these rules are very useful because they provide a clear, modern, and common sense procedure approach under which effective arbitrations can be conducted. I am now going to hand back to Kate, who is going to speak about arbitration in the international context. Thank you, Kate.
Thank you, Jennifer. So stepping back, we don't have it on the slide, but one of the questions, of course, at the outset is whether the arbitration is international or not. And in terms of that aspect, the law here in Canada is that if the proceeding or the dispute, sorry, has parties that have places of business in different countries, then the arbitration will be considered international. Alternatively, if one of the parties has their place of business outside of Canada, it can also be considered international. If a substantial part of the obligations under the commercial relationship are to be performed outside of Canada, then again, it can be international. And finally, if the place of the subject matter of the dispute is most closely connected to a place outside of Canada, it can also be international. The dispute for our international commercial legislation to apply, it also has to be a commercial dispute. And commercial is widely interpreted to cover all types of relationships that are of a commercial nature. So obviously trade transactions for the supply of goods, distribution agreements, consulting, engineering, factoring, anything that is in a basically a business context will be considered commercial. And then the international, if you have international as well, the international commercial arbitration legislation will apply. One of the advantages in the international context, of course, is that because arbitration is private and parties choose their adjudicator, they can choose that adjudicator based on expertise, regardless of borders. So for instance, a Canadian arbitrator could be chosen where the parties are in other countries, the United States, somewhere in Europe, because they have expertise in the subject matter of the dispute. And that's a pretty key component when you go to court here. Other than Ontario has a commercial list for commercial matters, but it's only certain things can get on it. You don't get to choose your judge. You don't get to choose the judge who practiced in securities litigation, for instance. When you have a securities matter, you just roll the dice and you go, and you might be in front of somebody who was, in fact, a family lawyer when they were a lawyer. And so this is kind of a really good thing about arbitration. And you can do that in the domestic context as well. But in the international context, you don't have to worry about the borders. Somebody neutral. I mean, the key is neutrality. Someone who doesn't have any interest in either party. There's the New York Convention, which allows for international arbitration agreements and awards to be enforced across borders. More than 160 countries have signed on to that, including Canada and the US. It's also my understanding is a signatory for commercial matters. So unless you can show that there was a defect in jurisdiction, that the arbitrator or arbitrators, if it's a panel, went outside of their lane and their jurisdiction as defined by the contract, or there was procedural unfairness, as Jennifer told you, you can't contract out of the duty of fairness. So unless you can show those defects, the award will be enforced. We've got the URL there for the New York Convention. Each of the Canadian provinces has statutes that govern international commercial arbitration as well as domestic, as Jennifer said. And we've used the example of Ontario, the International Commercial Arbitration Act. In that statute, Ontario adopted the whole model law on international commercial arbitration. And the model law, I've given you the website citation for that. It covers all stages of the arbitration and is intended to reflect a worldwide consensus on aspects of international arbitration practice. The UN Commission on International Trade Law, UNCITRAL, as it's called, also has arbitration rules that parties could choose to use in a non-administered arbitration. Again, similar to domestic, the contract will govern, and it may set out an institute that will govern the arbitration. And if it doesn't, then the parties can choose which rules they want to proceed under. So governed by the contract, and then there's choice of parties. We've also listed there some of the other rules. There's the International Bar Association has rules as well. There's Prague rules and the ICC. I think that might be it for the arbitration piece. Unless anyone has any questions about that area, we're going to turn it over to John and Michael to talk about some cross-border litigation issues.
Okay, I think we'll forge ahead then. Thank you, Kate. Thank you, Jen. So I'll be speaking first a little bit on enforcing foreign judgments in Canada, and then I'll turn it over to John after giving an introduction to obtaining evidence as well, and he'll cover the remainder of that topic in class action. So once you've gone through, whether it's the arbitration process or the court process in the US or the UK or whatever jurisdiction you're in, you'll need to seek to bring an enforcement proceeding in Canada to recover assets that might be located here. And the first question you'll have to ask is, where are those assets located? Because under the Canadian court system, we have the federal government, which manages foreign affairs, but then each province has the authority to legislate over the court processes and procedure in that province, which means that it does vary from location to location. And if you want assets in Ontario, you can't get a judgment recognized in BC to do that. In fact, recently the Supreme Court also ruled that because the provinces have reciprocal enforcement legislation, you can't register in one province and then use that reciprocal enforcement legislation to bounce from province to province, chasing the assets. So it's very important from the outset to make sure that if you're going after assets in Ontario, that you know that they're there and that you start a proceeding there. The first step will be to serve the Canadian party with the order to make sure that they're aware of it. The necessary process to follow would be the Hague Convention, which can be long and cumbersome and requires forwarding the originating process to your own country's forwarding authority, which then sends it potentially to Canada's. And as we talked about with federalism, it might go to the federal system before it gets disseminated into the provinces. It can take a long time, but if you want to make sure that you followed the letter of the law, that's the process you have to take. Fortunately for us, we can kind of circumvent that process because Canadian courts have generally accepted that personal service through a process server is sufficient for the purposes of bringing the order to the attention of a Canadian party. And I spoke briefly about reciprocal enforcement legislation earlier. So the provinces have it between themselves for provincial judgments, but some of the provinces have also enacted reciprocal enforcement legislation with other jurisdictions. Kate mentioned the New York Convention, which is very effective for arbitral awards. It mandates the recognition and enforcement of arbitral awards arising out of signatory jurisdictions. And although it expedites the process, more often than not, the statute supplements but does not override the common law, which goes to, and I'll speak about it a little bit more in a minute, but what Kate said about how if there's procedural unfairness, even an arbitral award can end up not being enforced in Canada. The elements for enforcement, the court has set out 3 elements for recognizing the judgment and enforcing it. Before I jump into the 3 elements, I want to note that the key principle throughout the entire process is comity and deference to the laws of other nations. more often than not, Canada isn't going to look, the Canadian courts aren't going to look at the terms of the order itself. They'll look at whether the order came out of a court of competent jurisdiction, is final and conclusive, and is adequately precise. And then once that's been established, they're usually happy to enforce it and defer to the court that granted the order in the first place. With respect to competent jurisdiction, the courts will look at whether the parties involved had a real and substantial connection to the original jurisdiction that issued the final order, or whether the party who is in Canada attorned to the jurisdiction by defending the proceeding or being involved in it in another way. With respect to real and substantial connection, the Supreme Court has set out a test which usually looks at whether the party lived in that original jurisdiction, was carrying on business in that jurisdiction, committed a tort there, or if a contract connected with the dispute was made in that jurisdiction. It's been the same test for decades now, and continues to apply. And for the most part, it can be established through your typical affidavit evidence. With respect to final and conclusive, the courts usually look at whether the rights to appeal have expired. It's not necessarily the case that all rights to appeal need to have expired. The official test is where the original court no longer has the power to rescind, but it can still be considered final while under appeal. Now, more likely than not, if you try to bring an enforcement proceeding before all rights of appeal are exhausted, the court will stay the enforcement proceeding until that appeal or the rights to appeal have concluded. And in terms of adequately precise, originally this meant that the judgment had to be monetary in nature and a very specific amount of money as ordered in the judgment. However, in 2006, the Supreme Court expanded the scope to include forms of relief such as injunctions, specific performance, constructive trust, and declaratory relief. Going back to the principle of comity, the judgment simply has to be of a nature that the principle of comity requires the domestic court to enforce it. So I won't go through the full list of considerations that a court will look at for this purpose, but it usually relies on how clear and specific the terms of the order are. Because this can apply to interlocutory injunctions as well, some case law has dealt with this, and it remains a little bit unclear how courts will apply it. More often than not, it will come down to a case-by-case basis, which is why it's important to get Canadian counsel involved early and sort of suss out what issues you might run into if you're seeking to enforce a judgment that isn't strictly monetary. There are some defenses to enforcement. It's not a sure thing. One of the main ones is limitations period defense. So in Ontario, for example, that's a standard 2 years. But as we've talked about, because the provinces can legislate over their own courts, that can vary from province to province. The limitation period starts to run from the date that the appeals have been exhausted, because the courts have ruled that that is when the claim is discoverable. They assume that the parties involved will take all reasonable due diligence to locate and track down enforcement opportunities, which makes it very important to, once you have a final order, if you think that there are assets in another jurisdiction, to start to make inquiries into that to make sure that you don't miss the limitation period. The next offense is whether the order offends public policy. Now, this means that it needs to offend Canadian principles of morality or justice. More often than not, this defense is reserved for cases where a judgment was obtained through corruption or bias. It can't simply be that the judgment itself is of such a size that Canadian courts might not have granted that level of damages if it proceeded in Canada. Similarly, if the judgment is obtained by fraud, that will also, a Canadian court will refuse to enforce it. That can go to the jurisdiction, whether or not it was brought in the wrong jurisdiction and obtained in the wrong jurisdiction via fraud or to the merits of the case. If you're going to raise a fraud defense on the merits of the case in Canada, it has to be completely new evidence that was not discoverable or could not have been put before the original court. And that's, again, going back to comedy, the courts are very consistent that if it could have been dealt with by the original court, it ought to have been dealt with there. And that ties into the lack of natural justice as well. This is reserved for if the party that the order is being enforced against hasn't received notice that that proceeding was ongoing, or if the judgment was obtained by bias, then the court will refuse to enforce it. Once again, bias would have to be discovered after the fact, because if you could have raised bias at the time, then the Canadian courts will say it ought to have been done in the original court. Finally, there are penal judgments, and that would typically mean that the judgment is of a case that a court would consider it a penalty in nature, reserved for certain cases where in Canada it's illegal to charge a certain amount of interest on court judgments or on any sort of loan, I believe, and that if the judgment charges 60% interest or more annually, then it won't be enforced in Canada. However, although penal judgments can also apply to public law, there have been cases which have recognized judgments against people who have breached environmental protection legislation because Canadian courts have found that reversing environmental harms is something that deserves comedy and respect for deference. So just a couple final points, going back to the principle of comedy and deference. The courts, more often than not, will defer to the original court so long as it can be shown that the judgment was obtained through the proper processes. It is important, nonetheless, to act quickly, because if there are assets in a Canadian jurisdiction, the limitation period begins ticking as soon as the right to appeal has been exhausted, and to top it off, you need to make sure that you are proceeding in the right court and starting the process as soon as you can, once you've obtained that final order. Moving now to obtaining evidence in Canada. Similarly to enforcing a judgment, you have to bring the request to that witness's attention. And more often than not, you can start by simply asking the witness whether they will voluntarily appear in the proceeding. But if they say no, which unfortunately does happen, you need to be able to compel them to appear. You can't simply do that via subpoena. You have to obtain what's called letters rogatory from the court in your jurisdiction, and then seek to enforce the letters rogatory in Canada. Similar to enforcement, the principles are comedy, deference, and international respect. So more often than not, these requests to enforce letters rogatory are granted as a matter of course. Nonetheless, because more often than not, you are seeking to compel somebody to testify because you have a specific date that you need them to appear on, it's very important to involve Canadian counsel early, as in Canada, you might have to wait months for an application, and that date could very well be beyond the time that you need the person to appear. So if you suspect that you need somebody who's in Canada to testify in the proceeding, reach out to Canadian counsel early, send the request for voluntary testimony early, and getting this process going can be very helpful in the long run. The court will ultimately look at whether the letters rogatory reach a threshold test before they dive into whether they'll exercise their discretion to grant the request. More often than not, if you obtain letters rogatory from your own court, it will be in the form of an order that sets out these 4 requirements. But the requirements are, as it says on the slide, that the foreign court desires evidence, has jurisdiction over the proceeding, and that the matter is civil, commercial, or criminal, and the witness is within the foreign jurisdiction, or in this case, it would be Canadian jurisdiction. I'll now turn it over to John to discuss the discretionary factors that a court will consider when granting letters rogatory, as well as class actions.
All right. Thanks, Michael. Can everyone hear me? I'm using new headphones for the first time in a presentation, which is a dangerous idea. Okay, good. So Michael, just want to pick up on something Michael said about obtaining evidence in Canada. This is sort of true for everything that we talk about today, which is if you have anything in your practice that touches in any way on Canada or May, it's worthwhile reaching out to a Canadian lawyer, preferably us, but any Canadian lawyer in advance, because we're having a real crisis right now in our civil justice system. Court delays are incredibly long. You can't get a motion date in Toronto until 2025. And so early notice is very important for us so we can start thinking about ways to deal with it, because I have on more than one occasion run into issues with U.S. counsel where they need something quick, and I can't promise them I'll get it to them quickly. The courts in Toronto are usually open to and will hear about concerns about timing in U.S. proceedings, but it is very important to flag it early, just put it on our radar, and it's something we can start thinking about. So Michael introduced sort of the threshold test for obtaining evidence in Canada. The other factors the courts will consider are listed there. I'll touch on some of them when I get to the points about things to keep in mind. But as a general principle, our Court of Appeal in Ontario has recently said, because this process has gotten a little cumbersome and remains cumbersome, but the Court of Appeal in Ontario has recently said that Canada and the United States are, closely tied allies, commercial entities, and that these sorts of requests should be approved as a matter of course, or at least that should be the default. And so, for the most part, you will be able to get your letters rogatory enforced in Ontario, but you still have to jump through the hoops. So, turning to the things to keep in mind. The first is the witness's province of residence, and as Michael was referring to earlier, Canada has a federal court, but it's not a federal court like the U.S. federal court. So it is tasked with very specific things within the federal jurisdiction, like immigration, taxation, interactions with the federal government. So if you really need to know where your witness resides, because it's the provincial court that's going to have the jurisdiction to compel them to attend. So that is very important to know. The second one is what discovery has and could be done in the U.S. And so when I look back up at the list of factors, two things that will catch a judge's attention in Ontario is the evidence necessary and is it not otherwise obtainable? So we are often dealing with cases involving corporations, and those corporations may have cross-border offices and locations. So the court here will be reluctant to grant a letters rogatory if the corporation itself is one of the parties, it has operations in the U.S., and that U.S. company could presumably, the U.S. base could go to say to the Canadian operation, say you need to send this over. So they really want to ensure that the parties to the litigation itself have sort of exhausted all of the ways they could get the information from the U.S. procedural rules that are available to them, whether they're in state court or federal court in the U.S. The second one is related, which is what discovery has been done and could be done in the U.S. A potential successful response to a letters rogatory is, they haven't completed their depositions there yet. We don't know if my client's evidence is necessary. So making sure that what reasonably could have been done has been done, so you can go to the court and be as specific as possible and say, look, we've conducted all of our depositions. This has become an issue. We need evidence on this point. This person is the only person who can give that evidence, or this is the only company that has those documents. And the last thing I'll put down there is one of the major differences, at least in my experience, between the U.S. civil justice system and the Canadian one is we don't have an endless right, and maybe, no, it's not endless, but we don't have a broad right to deposition. So when you have a corporate party in Canada, or at least in Ontario, you only get to examine one representative from that party. That's it. So we call it the discovery process, oral discovery. Our oral discovery is much more limited. And that becomes relevant in requesting evidence in Canada, because if you come to a Canadian court and say we need to depose, 15 people who are in Canada, especially if they're all sort of related or may talk on similar issues, the Canadian courts say, well, we're not going to let you conduct, what is sometimes termed here as US style discovery through the Canadian court system. So again, all of this is to say, when you come to a Canadian court, you really want to be able to tell the judge, look, this is what the information we need, this is why we need it, and this is why we can't get it without your help. And as long as you can do that, and it's not a particularly scrutinized exercise, but as long as you can sort of explain that, you're going to get your request granted more times than not. The last thing that I always tell US lawyers when it comes to getting evidence in Canada is it's expensive. Because not only do you have to pay for your own, the whatever Canadian counsel you or your client hire, but you actually, the law is currently that you actually have to pay for the witnesses' lawyers as well, both in responding to the application and to represent them during the examination. So Michael and I recently had, so our approach is usually not every Canadian lawyer is aware of this rule, so we don't raise it to the other side's attention. We see if we can get the order enforced without them asking for costs. And Michael and I think it was last year, actually had a case where to our client's benefit and to our glee, the lawyer on the other side didn't ask for his costs to be covered. But most lawyers will know that rule and say, okay, well, we won't oppose the order for the examination, but we want you to pay our costs. So in that case, what the courts have done and I think is relatively effective is we'll hear the party seeking the evidence position on a cost cap. So, we'll cover your costs up to X amount, 8,000, 10,000, depends on sort of the length of the examination, the document production obligations, and that is the way the courts deal with it. But it can be an expensive proposition to get evidence from someone in Canada if you're not in Canada. Which is, again, going back to the things and keep in mind, all the more reason to think hard about how important it is to get that evidence in the context of your case. So that's sort of it for obtaining evidence in Canada. What I'll do is I'll talk about our last topic, and then we can see if anyone has any questions. So the last sort of topic I wanted to speak about is cross-border class actions. Because that's another point where we find that our practice intersects with, in particularly U.S. counsel, although to a degree there's global, we see more and more global class actions arising. But because of the sort of the long-term relationship and the strong commercial relationship between Canada and the U.S., we sort of act as maybe a substantially smaller mirror when it comes to class actions and civil litigation. So in Canada, there is generally a low bar to certification. So getting a claim certified as a class proceeding is a fairly straightforward test, although certification hearings have historically been very hotly contested. And that's because after a class is certified in Canada, more likely than not, the case settles. And so parties would put a lot of time and effort into trying to either prevent certification or narrow whatever issues in class was certified, because that ultimately became the starting point in the settlement discussion. That has changed, and more defendants are actually pressing on to have the common issues heard on their merits. The courts have shown more flexibility in how they approach merits trials in class actions. We recently did one for Ford, where the entire trial in a $1 billion class action was done by way of a written record, and so the merits were heard and we prevailed, and so more and more defendants are pushing on that. The other sort of trend we're seeing in class actions in Canada is Ontario has always been a bit of a leader in class actions legislation. So about 2 years ago, Ontario amended its class actions legislation to make the bar, to raise the bar for certification. So they've introduced things that may be familiar with some U.S. jurisdictions, like a predominance requirement. So the common issues have to predominate over the individual issues. They've also placed tighter timelines on plaintiffs to bring and certify their motions. And what that has had an effect of doing is move a lot of class actions to British Columbia, where which is another large province, has a good judiciary, hasn't amended their class action legislation yet, and the judiciary is also generally seen as more plaintiff friendly. But again, as these issues arise in the U.S., you pick a province to start your class action as a general rule, but you certify as a national class. So you don't have to start an action necessarily in every province. You can pick which your more favorable province is. And so for that reason, another trend we see here is that lawyers in Ontario are getting themselves called in BC so they can appear before the BC courts. And one of our partners is called in BC now, so that we have the ability to act in class actions there. So the last bit of the class actions bit I wanted to talk about is sort of what happens. Again, we consume a lot of the same products, we use a lot of the same companies. And when I say we, I mean Canada and the United States. And so often, and our laws are broadly similar, although, differ once you sort of dig into them. So what typically happens is Canadian plaintiffs' counsel will sit on their hands and wait around and monitor class actions filings in the U.S. And some of our more prominent plaintiffs' counsel have relationships with the prominent U.S. plaintiffs' counsel. And what they'll do is the U.S. lawyers will do all the work. They'll file the claim, they'll get it going, and then you'll get a copycat class action in Canada. And so what usually happens is the Canadian process starts slightly afterwards and then sort of follows along the American process. This can be when the class action has the meat to it and there's actually some serious issues to be worked out. This actually proves to be beneficial for everyone. Most sophisticated plaintiffs' counsel will work with us and the U.S. counsel to sort of avoid duplication of costs and efforts. A lot of the evidence that is relevant in a U.S. proceeding will be relevant here. So it's not a bad system. The problem is not the problem. Well, sometimes the problem is what happens is if a U.S. case settles, the plaintiffs' counsel rule of thumb is that the settlement in Canada will be 10%, the size of the U.S. settlement. So there's 300 million Americans, give or take. There's 30 million Canadians, give or take. Both of those numbers have gone up, but that's roughly the size. And so a lot of plaintiffs' counsels are sort of also, in addition to mirroring the claims of U.S. counsel, will seek the same amount, the proportional amount of recovery. And in our experience, defendants have become, in the last 5 years, much more resistant to just saying, okay, we'll do 10% of what was done in the US. And that's because, while I said the laws are broadly similar, there is large differences between Canadian and American law, both in terms of consumer protection, but also in terms of damages awards. The concept of a nuclear verdict is not something you talk a lot about in Canadian commercial litigation with product claims or consumer claims. It's possible, but our damages awards are just not on the scale that you see in the US. And then two other things that are sort of hot topics in Canadian class actions law, which relate to maybe echoes of things that are going on in the US is there's ongoing issues about when form selection and arbitration clauses are enforceable. There was a big case in Canada involving Uber where the court found that the Uber arbitration clause was not effective to prevent a class proceeding against Uber. And then the final thing is the real sort of growth area in class actions in Canada is in privacy and cybersecurity class actions, which again, often these sort of, when it's a large multinational, follow-on issues that have arisen in the US. So I have successfully left us with 6 minutes for questions, and I think Arnie wanted to say some things. So I will, if anyone has any questions, we're happy to answer it. Otherwise, we will turn things over to Arnie.
Well, I actually have some questions. So
yeah, go for it.
And I don't know, I'm thinking about this both in the arbitration context and then in sort of the follow-on to maybe the last point you talked about privacy. How are terms of use for websites handled where there is an arbitration provision in the terms of use that can functionally be buried at the bottom of a homepage, as an example, and whether courts would enforce arbitration as the mechanism for the website owner and the user, the subscriber or whatever to the website to proceed. Can they force arbitration? This is becoming a hot issue in the US, and just sort of how has it come up in Canada? And if so, how? And it sort of crosses both the litigation, potentially class action issues, because we've seen things relative to the privacy questions in the US, and then separately with the arbitration presentation.
Kate, I don't know if you want to answer that, or I'm happy to, whatever you.
You can, yeah, you can go ahead.
So I mean, it falls within the general. So yes, it's an issue here. It comes up frequently. It falls within the general test for whether or not an arbitration clause is enforceable. And essentially, the way our courts have currently dealt with it is they analyze it under the sort of unconscionability analysis. So like the answer to a client who comes to us is, you know, what does your arbitration clause provide for? How well was it brought to their attention? So a arbitration clause that allows a consumer to have, you know, attend an arbitration at a relatively low cost, you know, without leaving their home and flying to a foreign country or a foreign state, that's more likely to be enforced regardless of how much it was brought to their attention. But if you had a clause that buries something that says, you know, you have to fly to California under this, you know, sort of this set of rules, and you got to pay each party has to pay $10,000 as sort of an initial administrative fee, then that is where a court will look and say, okay, that's unconscionable. That's effectively depriving them of their civil rights. So there's not a clear answer yet, but that's sort of the broad approach the courts are taking. So
I mean, the sort of, I don't know if it's a follow-on, but in other words, do you need I'll call it a click to accept terms of use as the mechanism to assure that the arbitration clause is enforceable? And if you don't have a click to accept, would a court rule out the arbitration provision?
So I'll let my colleagues correct me if I'm wrong, but my understanding is there's no bright line rule that you need to have a click to accept it. That would be a factor, again, in the court's weighing of it, you know, whether it was brought to the attention or not. But no, there's no specific requirement that there has to be a click to accept.
Okay.
So you can still say, you know, when you entered my website and, you know, used my service, by using my service, you agreed to the terms and conditions, and therefore you're bound to this. And then the court's going to look in the broader unconscionability analysis whether that should be enforced.
I had one other question. I don't know if anybody else has anything to ask. On the where in deposition context you're paying both your lawyer and the witness's lawyer, does that raise any privilege issues?
Only to the that's a good reason why you ask for a cap. So not at the immediate outset, no, because you're just saying I'm going to pay you whatever. You know, the rule is I have to indemnify your costs, right? So lawyers should in theory be able to submit an invoice. You know, your invoice can either have sparse descriptions in the time, or you can just say, you know, here's my invoice. One of the reasons to have a cap is if you got an invoice for a lot of money and you said to them, look, I don't believe you spent this much money on this file or doing this, or this is inflated, you could get into a tricky territory where they would have to justify the money they spent, they would have to, you know, go into the activities they did, which could then go into issues of privilege. So it's one of the reasons why courts are amenable to imposing caps, because it's sort of like, then we don't have to sort of turn our mind. The court sort of pre-assesses, you know, $10,000, that's a reasonable amount of money. That's your cap. And everyone know, you know, as a defendant, or as the party seeking the order, I know they're obviously going to spend the 10,000, right? So I always try to pick argue early for a smaller cap, because I'm expecting that bill to come in at, you know, 5 cents short of the cap. So,
okay,
yeah. When someone else is paying, it's a lot easier to not pay as much attention to your time.
Any other questions from anyone? Otherwise, I'm happy to let Arnie run through a couple of announcements before we close up.
Yeah, well, thank you. It was a great presentation, and again, we'll keep it posted. I'll just mention, there's a new firm that joined, actually, it'll be based in Connecticut, that's involved in investor class actions. And it's called Levy and Kohansky, and I will sort of connect them with Lloyd, because I don't know if there's potential cross-border business, but they look at investors in stock fraud, security fraud issues. And so there may be some business opportunities there. I also want to underscore, and I'll mention a couple of things, but also, if Larry is still on, he may want to highlight the litigation program that will be in Chicago in June.
I was going to ask if you had a date.
Yes.
John and I went last year. It was a great event. It was really good.
I'll just mention just a couple of quick things and then turn it over to Larry. Annabelle has been just fabulous in outreach. We get many requests for firms to join the network. In the last month, beginning of this year, we've had growth and actually first members in Africa, in both Kenya and Nigeria. We have another inquiry from Zambia, and I'd say that the entire continent is up for grabs. And anybody that has connections in Africa with firms, I certainly want to encourage that. And also, if your office does activity in BC, I think Vancouver has always been a goal and a target as a potential additional market for the Canadian membership. And I'd certainly like to, have some conversation about how we can engage more firms there. IMBLF will be hosting receptions at a number of international bar events. The first will be in Tokyo in April for the Inter-Pacific Bar Association, and we've got a growing membership in the Asia Pacific region, and so that we're looking forward to both having the members meet and connect, but also add new membership. The same will be true in Atlanta in May at the INTA, International Trademark Association Conference. And then the IBA will have an annual meeting in Mexico City in September, and we'll be hosting a reception there as well. And it's again for any firms that have participation in those conventions to reach out. We'll reach out to you, you reach out to us, and make sure you're engaged and meet others in the network that'll be attending. Finally, we're going to have a black tie weekend in Washington, D.C., November 7th to 9th. Details are in the process of being inked, I'll call it. The highlight black tie dinner will be at the Organization of American States headquarters building, which is one of the grand Beaux-Arts buildings in Washington. We're planning a very full and great weekend. There will be some significant emphasis on our Latin American, Central and South American membership, but the OAS headquarters is also home to the membership of the US and Canada. And I'd like to sort of think about coordinating with Lloyd and the Canadian membership about ways to highlight Canada as part of the program as well. So put that on your agenda, and I'm going to turn it over to Larry, who I believe Larry is still on.
Yep, I'm here.
Yep.
Great.
So first of all, thanks for the presentation. It's really interesting and potentially useful. So appreciate that. The Chicago fly-in is scheduled for the 13th and 14th of June. So dinner on the kickoff dinner would be on the 13th, meetings on the 14th for folks who are staying, longer, another dinner probably on the 14th. We've got a couple of topics that we are talking about, including legal issues that arise around the use of artificial intelligence by lawyers, mostly sort of around ethics and competency issues. Some apparently new legislation around cryptocurrency and litigation that's arisen from that. There's a Supreme Court case that's been argued in the United States waiting on a decision, which will have potentially very significant impact on the practice of administrative law and the sort of the legitimacy of agency rulemaking. So Larry Ebner, who's a member in DC, wrote an amicus brief in that case. So hoping that he can talk about his side, and I'm hoping someone can talk about the other side. And then we probably have at least one more slot for topics. So I haven't done this yet, but we will circulate to all the membership, or at least to chapter presidents one way or the other. Update on what's going on, a save the date, and then a request for if anybody has something that sort of thematically fits in that they want to speak about. Be great. So we're looking forward to seeing you guys. It was a great time meeting you all in Chicago last year. It's at the same place, same hotel, right by O'Hare. Arnie, I confirmed that yesterday, so we should be all good to go. All right, so great.
That's great. Yeah,
Thanks.
sounds great.
Yeah.
Well, thanks so much again to the DMG team. This presentation will go up on the website. I'll make sure it's circulated so everyone has it. And if there are follow-up questions, I'll circulate people's contact information as well. And if anybody has any other questions, otherwise, the next time we'll see any of our members will be in April in Tokyo. But this is the last of our Great Legal Minds webinars for the time being. And so we'll connect soon. And if anybody needs anything, they're more than welcome to shoot me an email in the meantime. But thanks again to the team. We really appreciate it. And this was fantastic, very, very thorough. And I'm sure the members will appreciate it.
Our pleasure. And thank you, Annabelle, for organizing.
Of course.
Thank you.
Thanks, everyone. We'll speak soon. Thank you so much.
Thanks again.
Take care. Nice to see all of you. Bye.
Bye. Bye.
Bye.
Hi, everyone.